When it comes to gun rights in America, we've seen plenty of controversial rulings over the years. But every once in a while, a decision comes along that's so bizarre, so hard to believe, that it makes even seasoned gun owners, lawyers, and dealers stop in their tracks and say, "Wait, what did that judge just rule?" That's exactly what happened recently in New Jersey, where a federal judge issued a decision that essentially says only Colt-branded AR-15 rifles are protected by the Second Amendment, while nearly identical AR-15s from other companies are not. This is the kind of legal hair splitting that has gun rights advocates furious, anti-gun groups scrambling to defend it, and constitutional scholars scratching their heads. In today's video, we're going to break it all down: what the ruling says, why it makes no sense, how it impacts gun owners right now, and why it could end up in the Supreme Court. By the end, you'll understand why this single case could reshape the entire future of AR-15 ownership in the United States. The story begins with a federal judge in New Jersey, Peter G. Sheridan, who in 2023 ruled on the state's long-standing assault weapon ban. New Jersey has had one of the toughest positions on AR-15s since 1990, specifically naming the Colt AR-15 in its statutes as a banned firearm alongside AKs and others. But the state law also extended that ban to substantially identical rifles made by other manufacturers. That phrase, substantially identical, became the heart of the lawsuit. Gun owners argued that the law was vague, arbitrary, and unconstitutional under landmark cases like District of Columbia v. Heller in 2008 and NYSRPA v. Bruen in 2022. Instead of striking down the vague language, Judge Sheridan did something no one expected. He carved out an exception. He ruled that the Colt AR-15, and only the Colt AR-15, was protected under the Second Amendment, while rifles from Ruger, Smith and Wesson, Bushmaster, and others did not enjoy the same protection. In other words, it wasn't about the design, the caliber, or the function. It came down to the brand stamped on the receiver. Think about how absurd that is for a moment. Mechanically, an AR-15 is an AR-15. Whether it says Colt, Ruger, or Daniel Defense on the lower receiver, the rifle works the same way. They fire the same 5.56 NATO or 223 Remington ammunition, use the same magazines, operate with the same controls, and in many cases, even share interchangeable parts. Uppers, stocks, triggers, the aftermarket ecosystem is built precisely because AR platforms are standardized across brands. Yet, according to this ruling, if your rifle has the Colt roll mark, you're exercising a constitutional right. If it has any other roll mark, you might be committing a felony under New Jersey law. It's like saying a Ford F-150 has the right to drive on public roads, but a Chevy Silverado doesn't, even though both are pickup trucks with the same function. Gun owners in New Jersey were understandably outraged. Forums lit up overnight with people posting photos of their ARs, asking if their rifles were now considered illegal simply because they weren't stamped Colt. Dealers faced immediate headaches. Shops selling Ruger AR-556s or Smith & Wesson M&P 15s didn't know if they could continue business. Were rifles already sold suddenly contraband? Could they sell parts? Nobody wanted to risk felony charges, which in New Jersey can mean years behind bars. Advocacy groups like the Association of New Jersey Rifle and Pistol Clubs blasted the decision, calling it nonsensical, unconstitutional, and a direct violation of Supreme Court precedent. And they had a point. The Supreme Court in Heller made clear that firearms in common use are protected under the Second Amendment, and by every measure, the AR-15 platform is the very definition of common use. Industry estimates put more than 20 million AR-15 style rifles in civilian hands as of 2020, and that number has only grown since then. During the surge of 2020 alone, background checks hit record highs, with millions of Americans purchasing their first AR-15. Whether it's made by Colt, Ruger, or any other manufacturer, the AR-15 is the most common rifle in the United States. For a judge to tie constitutional protection to a trademark name rather than the firearm's function completely ignores both engineering reality and established legal precedent. So, what happened next? Naturally, the case didn't stop at the district court level. It exploded into the appeals process. Initially, it was headed to a three-judge panel in the Third Circuit Court of Appeals, with a hearing scheduled for July 2025. Based on the lineup of judges, two with histories of siding with gun control and one moderate, many observers expected gun owners to lose 2-1, leaving New Jersey's AR-15 and magazine bans intact. But then, something unusual happened. Before the panel even issued its ruling, the entire Third Circuit decided to step in and rehear the case en banc. That means all 13 active judges would take part, not just 3. Courts don't do this lightly. It signals that the case is too big, too important, and potentially too disruptive to let a small panel decide. It also suggests that the panel's draft ruling may have broken sharply with Supreme Court precedent, forcing the rest of the court to intervene before being overturned later. Now, here's where the stakes get even higher. The current makeup of the Third Circuit leans slightly in favor of gun rights, with roughly a 7-6 split. If Judge Jennifer Mascott, a former clerk for Justice Clarence Thomas, is confirmed by the Senate, that tilt becomes even sharper. That means when the full court hears the case in October 2025, gun owners may actually have the advantage. And if the Third Circuit strikes down New Jersey's AR-15 and magazine bans, it would be the first appeals court to directly rule that Bruen leaves no room for these kinds of laws. That would create a circuit split with other courts, like the Second and Fourth Circuits, which have upheld similar bans. And when there's a circuit split, the Supreme Court almost always takes the case. Make no mistake, this isn't just about New Jersey anymore. If Sheridan's Colt-only logic had stood, it could have set one of the strangest precedents in Second Amendment history, tying constitutional rights to trademarks. Imagine other states adopting the same strategy. Sure, you can own this brand, but every other identical rifle is a felony. That slippery slope is exactly why constitutional scholars are paying close attention. The Supreme Court's framework in Bruen requires modern gun laws to align with historical tradition, and nothing in American history suggests that a right can hinge on a brand name. If one AR-15 is in common use, all AR-15s are. That's the core of the legal fight. The fallout in New Jersey has already been messy. Gun owners feel targeted, dealers are paralyzed, and advocacy groups are pouring resources into the appeal. National gun rights organizations have also taken notice, because if this logic spreads, it could become a blueprint for anti-gun states. At the same time, gun control advocates are nervously defending the ruling, knowing that if the Third Circuit overturns it, the ripple effect could dismantle other assault weapon bans across the country. The outcome of this single case could determine whether AR-15 bans remain viable under the Bruen test or collapse entirely. Looking ahead, all eyes are on October 2025, when the full Third Circuit hears the case en banc. The stakes couldn't be higher. If the court rules in favor of gun owners, we'll likely see the case fast-tracked to the Supreme Court. Justice Brett Kavanaugh has already hinted he's ready to hear an AR-15 case, and the conservative majority has shown no hesitation in striking down lower courts that sidestep Heller or Bruen. With more than 20 million AR-15s in civilian hands, it's impossible to argue that they aren't in common use. And once the Supreme Court takes up the issue, we could see a ruling that reshapes gun rights in America for decades to come. So where does that leave gun owners today? If you're in New Jersey, the situation is still uncertain. The appeal is ongoing, and until the higher courts rule, the laws remain in effect. But nationwide, this case is a flashing neon sign. The fight over AR-15s is far from over, and the courts are finally being forced to confront the issue head-on. The idea that your constitutional rights depend on whether your rifle says Colt or Smith & Wesson is as absurd as it sounds, and most legal experts believe it won't survive long-term. But until the courts resolve it, gun owners are stuck in a bizarre and dangerous limbo. In conclusion, the Colt-only ruling out of New Jersey is one of the strangest and most consequential decisions we've seen in recent memory. By tying Second Amendment protection to a brand name, Judge Sheridan created confusion, fear, and outrage, not just in New Jersey but across the entire country. The appeals process has now elevated the case to the Third Circuit en banc, setting the stage for a potential showdown at the Supreme Court. If that happens, the decision could not only overturn New Jersey's assault weapon ban, but also set a nationwide precedent that finally clarifies the status of AR-15 rifles under the Second Amendment. For gun owners, this is a battle worth watching closely, because the outcome will shape the future of firearms rights in America. Thank you for watching. Stay safe, stay informed, and as always, stay prepared.